one of the analyst questions that they provided to us in advance, number 7, the analyst suggests that Bill C-244 suggested do-it-yourself approach to the diagnosis, maintenance, or repair of products in which technological protection measures, TPMs, protected computer programs are embedded. It would allow a person to circumvent the technological protection measure for these purposes and to use or offer equipment for these purposes. It would not, however, allow a person to offer or provide services for doing the same. So to you, Professor Centovanni, why does Bill C-244 seem to prioritize a do-it-yourself approach, considering that ordinary people may not have the know-how to repair products, such as motorized vehicles and personal electronic devices, and that allowing others to do it for them could bring new revenues to Canadian businesses?
Thank you for the question. So I would have to say that that's not my understanding of the bill that's proposed.
Okay.
In the sense that it would sort of equally apply to consumers who are do-it-yourselfers, but it would also enable, third-party repair technicians and others to be able to circumvent the TPMs as well. And so essentially what we would be doing if this bill were to be passed would be to give consumers the choice of either, tackling these repairs on their own or choosing, a service provider to do that for them.
Okay, that's helpful. Thank you. Another question the analyst provided to us states that computer programs embedded in products are typically licensed to consumers. To retain the right to use the program, they usually must comply with license, which may require that they do not circumvent TPMs for any reason. A person could thus breach the license, losing the right to use the program, even if the Copyright Act otherwise allows them to circumvent the technological protection measure. Does Bill C-244 overcome the challenge of licenses that restrict the diagnosis, maintenance, or repair of a product, even if it were allowed under the Act? And given that provinces have legislative powers over contract law, should the federal government engage with them on the matter of restrictive licenses? And I'll pose that to you again, Professor Centovanni.
Sure. So this is essentially a question of preemption. Does copyright law preempt provincial contract law? Maybe I would defer to Anthony on this since he has more familiarity.
That would be helpful.
In the United States, federal copyright law preempts contract law. Anthony, do you want to speak to this?
Certainly. I think this question evidences, and as I mentioned in the Canadian Right to Repair Berkeley article that's forthcoming, is federal provincial cooperation is essential here, and this indicates an area where coordinated legislation targeting the Consumer Protection Acts in the provinces is needed. So it would be nice if Bill C-244 also said that if you own a device with an embedded computer program, you have a license, an implied license to circumvent or to use the program to the extent that circumvention is necessary. We don't have that language in the bill. And obviously that would conflict with provincial jurisdiction. So this is where coordinated federal provincial effort is needed. But again, this bill is starting in the right spot.
Mr. Rossborough, would you be able to suggest any amendments to address the concern between the provincial and federal responsibilities in question here?
Amendments to Bill C-244?
Yes, that we could, could you suggest to us as a committee in future correspondence a possible amendment to get around this discrepancy between federal and provincial jurisdictions?
Yes, I'm happy to do that in writing with the other requests I've received.
Thank you so much. Would any other panelists like to comment on the relationship between the Copyright Act and the provincial powers? The dynamic between the province and the federal government on this? No? Okay. Well, then I have one more question if I have time, Chair.
You do.
Okay. Under Bill C-244, circumvention of technological protection measures would only be allowed for the purposes of diagnosis, maintenance, or repair of a product that we've stated. You've touched on this a bit, Mr. Rossborough, But how would this limitation be enforced in practice? If you could just reiterate a couple of those points for me. And could persons or companies which engage in the manufacture, importation, distribution, sale, renting, and provision of technologies, devices, or components to circumvent TPMs be held liable where these products are used for other purposes?
So as for the second question, I mean, it's not clear in the Act whether there would be liability. The liability would extend that far. That's an ambiguity that would require some further research. The first half of the question relates to essentially whether hinging the bill on a enumerated list of acts, right? Repair, maintenance, and diagnosis would be overly restricting. Is that the essence of the question?
Yes.
Yeah, and I mean, I think in a broad sense, that's a pretty wide range of activities, and that is inclusive of a lot of the activities that independent repairers need. However, I mean, it's foreseeable that there are future uses of TPMs which impair other public interest uses of technologies that the law should be able to respond to. It should be able to have a proactive approach, essentially. And so this is where my sort of suggestion that we move in a more regulatory direction comes from, is that we can actually, it's not a concession from a right to repair perspective. It's actually a way of thinking broader about the issue and responding to the uses of TPMs that undermine the public interest.
Okay, I appreciate that. And I was very apprehensive, however, in your earlier comment about the ability of our institutions to prevent big lobbyists from sort of taking over the process as we might have seen in the United States. But otherwise, I agree with your sentimentality. But in practice, I think it would be very, very hard from a regulatory perspective. And I think that's one of the big challenges we're facing, is just how broad in scope this legislation. And I was hoping Mr. Meow would be here today, but I guess he didn't show up again. But thank you to all the witnesses for your time today, and thank you, Mr. Chair.